Okay, you can probably start and just let other people join as they do.
Okay, well, hello and welcome to today's seminar on Alberta's new Prompt Payment in Construction Lien Act. My name is Bryan West, and for those of you who don't know me, I am a litigation partner in McCarthy Tétrault's Calgary office. I am also relevant to today's proceedings, the author of the text Builders' Liens in Alberta and Heintzman and West on Canadian building contracts, which are both fantastic beach reads for your summer vacation. Today, I have the pleasure of acting as your host. I'm going to be the first presenter and just a general busybody throughout today's proceedings. First, just a little bit of housekeeping. You can note at the bottom of the screen is the chat function. If you have any questions throughout any of this seminar, please use that chat function. You can target your questions to specific speakers, but I think probably the best way is just to send to the entire group, and then I will take those questions and make sure that they end up with the proper presenter as we go through. Second, also, please note that today's seminar is being recorded. We have a full digital house. We have a very busy agenda for the next hour and a half or so. It's a crack team of knowledgeable presenters from McCarthy Tétrault's Construction Group. Those presenters include, and this is not in order, but we have Scott Chalmers with us today. He's a business law partner at the McCarthy Tétrault Toronto office. He's also the national lead of McCarthy Tétrault's Construction Group. And Scott's presenting last, but to help us stick the landing, but I thought I'd give him first billing here as deserved. From the McCarthy Tétrault Litigation Department in Calgary, you will also be hearing today from Jocelyn Turnbull, Jordan Bierkos, and Andrew West. No relation, that last one. And finally, from the Calgary Real Property team, David Meier. With those introductions, let's get into this. First, I'm going to talk about a few of the key takeaways. So if you are not paying attention for the rest of this entire presentation, that's too bad, but pay attention now. The main thing that you need to know is that this matters. It's a fundamental change to the way that construction is regulated in the province of Alberta. It's keeping in touch with major changes that have happened both nationally and internationally, the advent of prompt payment regimes and adjudication regimes. It does not just touch upon the construction industry, it will touch upon anyone who builds on land, who sells land, who finances land. All of those industries are going to be affected, including mining, oil and gas extraction, et cetera, et cetera. The second major thing that you need to know is that, well, on that first topic, there's going to be growing pains. We know that there are a number of issues that are going to arise. We're going to walk you through some of them today. We certainly know that those that are prepared can take advantage, and those that are not prepared will certainly be disadvantaged, and there might be some shocks or surprises in store. The second major piece of information is it's time to update your precedents. That means that the old construction contracts or the old agreements or the old ways of doing business, in particular, the way that accounting is run, those things need to be looked at, those things need to be upgraded and prepared for the new legislation. It has always been important to value and invest in contract administration. It is going to be even more critically important after the implementation of the new act. And just a point on that issue, the act is supposed to come into force on July 1st, so less than a month away. That being said, it is unclear that the government is prepared to actually do that. Given what we are seeing, or rather what we are not seeing right now from the government, including the regulations that are supposed to go along with this new legislation, and the fact that a number of amendments are still in the process of working their way through the legislative system, I think it's unlikely that it's going to come into effect on July 1st, but better to be prepared than to be surprised. finally, at every presentation that I ever make on the Builders Lien Act, it's always important to keep a holdback, and we'll explain why that's still important on a go-forward basis. So let me set the stage for you in terms of why this is important. Timing is everything. The new prompt payment regime combined with the adjudication regime are going to change the way that disputes are handled and the way that payments are processed. So to give you one example, that's a real example from another jurisdiction, Scott Chalmers, who has practiced in many different jurisdictions and has great experience with this, will probably have a few war stories of specific examples of this. But let's talk about what happens after July 1st. Assuming that the contract is made after July 1st, the new act will apply. A proper invoice comes in. We'll talk about what that means. A proper invoice comes in from a contractor to the owner. It's jam-packed with all sorts of change order requests and additional work and all sorts of add-ins that the contractor says that it's entitled to. The owner disputes that, says those change orders were never issued, payment is not required, starts to send off its people to investigate what's happened, get a fulsome idea of the context of why these things are being claimed. In the meantime, 14 days goes by and they have not issued a notice of dispute, which is required under the new legislation. That means that that payment is now due. After 14 days, if you haven't disputed it officially, it is now due. Under the adjudication regime, if the owner tries to go up to adjudication to dispute the payment, too bad. You missed disputing it within that 14 days. It is now due and payable. The way that the legislation is written right now, it says that adjudication is final and binding. That means that you would have no appeal except a judicial review, potentially, of that decision. And you wouldn't win that judicial review because you didn't make your notice of dispute within the applicable time. Now, the government seems to be walking back from the final and binding adjudication system, so now it will be interim binding. However, interim can be a long period of time. We all, certainly in the litigation department, know how long litigation can last. It can last not months, it lasts years. And so that interim binding decision might mean that the owner is paying that jacked up invoice and has to bear that cost throughout the entire period. So that would be a nasty surprise to happen to your business. And that's one of the reasons why you should be prepared. Christmas gifts. It's a term that comes out of the UK. The UK, who first adopted this system, when they implemented this system, they had a calendar day system for adjudications. Well, guess what? So does Alberta. It's not business days, it's calendar days. So we don't know what all the timelines are going to be yet because the regulations have not yet been released. But imagine this. The contractor or the subcontractor has been sitting on its claim for many weeks, many months, building a case, getting expert reports, showing delay damages, showing schedule changes, all that sort of stuff. Building the record, sending letters back and forth. They prepare their giant claim of 200 pages plus all the schedules and addendums and the boxes of information that support it. And they drop it on your doorstep with an adjudication notice on December 24th. Now, throughout the Christmas break, your business has to be dealing with this on very short notice, and you're not nearly as prepared as the other side to fight that fight. And so you need to be aware of these things. You need to be aware of how adjudication is going to work. You need to update your contracts so that you can avoid these types of surprises. So these are some of the themes that we're going to be talking about today. Now, let's go backwards just very briefly and give you an overview and purpose of the Act as it stands and as it's going to be amended. So the purpose of the Act as it currently stands is currently called the Builders Lien Act. It's going to soon be called the Prompt Payment and Construction Lien Act. And you can see there, prompt payment is getting central billing. So the entire industry is becoming much more regulated, and this prompt payment is taking central billing, while the idea of the lien is a secondary consideration. And it may not even be secondary, it might be actually third or fourth in terms of the effects of what the Act is actually doing now. So what does the Act do? Currently, what it does is it provides a number of ways to improve the financial integrity of the construction project and to assist with the smooth flow of funds throughout the construction period. That's me quoting myself. The three main functions are liens, limited owner liability, and trust claims. So the liens and the trust claims are tools that are being used by contractors or subcontractors in order to induce payment on valid accounts. And the limited owner of the liability is a built-in function to say, owner, as long as you're doing what you're supposed to be doing, primarily keeping a holdback, you're never going to be on the hook for more exposure than what the value of your contract with the prime contractor is, or the general contractor is. So those are sort of the three, they work in concert with each other, but those are the three functions. The new Act is adding two new major sections to the Act: prompt payment and adjudication. Prompt payment is how you do things and how payments are made. And it's saying now your payments have to be made promptly within 28 days after the issuance of a proper invoice. The trend in the construction industry was getting up to 60, 80 days. So this is for those businesses that are still working on that model, this is going to be a big change. You have to be processing them within 28 days now, and you have to make a decision on whether or not you're going to pay it within 14 days. So that all of those internal mechanisms need to be updated. And then adjudication is to change how these things are handled from a dispute perspective. It's adding an entire new adjudication regime with adjudicators making decisions on an interim basis, resolving disputes over payments that are owed, over contract scope issues, over change orders, basically all the normal disputes that we have in a construction infrastructure project. So this is rounding out the Act and its applicability. Let's take a look at a typical construction pyramid. So this is just a very general setup in terms of how a project might look. Owner on the top, lender to the side. Money flows from the top of the pyramid to the bottom of the pyramid. And because of that strange relationship, it's not completely unique to the construction industry, but it's always applicable in the construction industry, is that the ones at the top have the money. And if there's a breakdown anywhere in the system at any one of those junctures, then the money can't flow. And those at the bottom suffer the most. They bear the most risk because they're doing the work up front. They're putting the material, the supplies, the labor, and yet they get paid last because they're the last in this daisy chain construction pyramid. And so this is what the Act was trying to fix. And it's been evolving over the last 100 plus years. I think probably 140 years if we go back to the first Act. And it's been evolving over time. And so they keep coming up with new ways to help juice the system and to respond to modern trends, modern events, and modern ways of doing things. The lien and the lien fund and the holdback system, I'm just going to talk about this very briefly because the new Act does make some changes to the way that this works, some modest changes, but generally this is what happens. The owner makes a payment to the contractor, $10. $10 is made to the contractor. $1, 10% of it has to go to the side and go into the holdback. The holdback is kept as the fund that those lower on the construction pyramid chain, that's what they get a lien on. That's what they're entitled to is a pro rata portion of the holdback fund. So normally, if a lien is the reason that you keep a holdback is because if a lien is filed, that lien is going to apply to the holdback. Solvent party. Here comes the liens. Great. You're protected. But if you do not keep a holdback, then bad things can happen. And instead of that lien going to the holdback, the lien is applying to the owner, and the owner's on the hook for the whole amount. So they've paid the insolvent party, the contractor, once the full 100%. Now they're on the hook to pay it again. And that's why we always keep a holdback. So that's just a brief overview of I'm not going to get into the entire lien system. We're going to move on to the new stuff, but that's a backgrounder for this information. Now I believe it's over to Andrew West to talk about the overview of the changes. Andrew?
Thanks, Brian. So as Brian mentioned, in many ways, the scope of the Act remains unchanged. However, it's expanded in a number of areas. There's a number of high-level changes, which are outlined here on the slide. So the two top-level ones being the statutory payment deadlines or the prompt payment system, which, as Brian mentioned, gets top billing under the new Act. And then the second one being the adjudication process. In terms of the nitty-gritty, there's a few other changes that I think stakeholders need to be aware of. One is there's been some changes to the lien registration period. Two is that several standard contractual terms are now precluded or prevented by the Act. And then the third one, again, touching on this notion of keeping funds kind of flowing through the pyramid or the chain, is that progressive release of holdbacks is now allowed. So the holdback process is now very much changed. And then a last point would be information rights are now sort of expanded and improved in terms of the type of information that can be accessed and also the people and the parties who can access that information. One general note as well is the transition provisions. So Brian mentioned that the new Act is going to apply to any contract that's entered into after this Act comes into force, which we're assuming is going to be July 1, if not later at this point. This is one area of contrast, for example, with the recent Act in Ontario. So in Ontario, what they had done is the new Act, the old Act would continue to apply, for example, to subcontracts that were entered into if the parent contract had been entered into and created under the old Act. We don't have that here. It's going to be a full stop, a full wholesale change when the new Act comes into force. Having said that, if you're in a tendering process right now, for example, or if you're anticipating an award in a tendering process being granted post July 1 or later, if the date ends up getting pushed, you may want to consider including language that makes clear reference to the new Act and making clear that it will apply. So in terms of some of these little changes, the registration holdback periods have changed. So the default period now goes from 45 to 60 days. Oil and gas, the kind of unique carve out that we have in Alberta, stays the same at 90. And then we have this sort of discrete third category now, which is work done in relation to concrete. So the purpose of this new carve out, and it is a somewhat unique one, I think in large part is motivated by the curing period for concrete rather, and potential issues on that front. So a number of the provisions have been expanded or reworded to specifically include concrete work. Questions still remain as to what concrete is going to include. Does it include form work? Does it include base preparation work? Does it include asphalt? These are some things that we would look for in the regulations. Notwithstanding that, there's things that likely will be dealt with, will have to be dealt with by the courts or through different processes going forward. Another thing to be aware of is the minimum amount has gone from $300 to $700, in large part to account for inflation and to discourage parties from clogging up the system with minor disputes. As I mentioned, several contractual terms are also now precluded or impacted by the new legislation. The big one is the effective elimination of pay when paid clauses. Sometimes parties have also tried pay when certified clauses. So while the Act doesn't explicitly preclude these provisions, notwithstanding the first version of the new legislation did, the practical effect of the prompt payment system, which Jocelyn is going to take you through, in effect prevents these clauses from being valid and being in effect. So long story short, parties must pay a proper invoice once it's received within the required timeline, even if the party above them in the construction pyramid has not yet been paid. Again, to keep funds kind of flowing through and to prevent this buildup of funds that parties are fighting over. That leads into the next point, which is the progressive release of holdbacks. So as Brian mentioned, the practice has been 45 days, and the current Act requires a 10% retention on every progress payment that is made. Under the new system, progressive release is going to be allowed at preset milestones. So this gives increased certainty to the parties. It also means that you should consider sort of when you're drafting your contracts, and in particular, because of this concrete carve out, you may want to consider ensuring that your language reflects concrete work such that it gives you, an additional 30 days on the timeline to be aware of. So this is just sort of a representation of the current system. As Bryan mentioned, every payment is 10%. The holdback fund grows and grows. Monies that otherwise could be flowing through and helping grease the wheels of the project are sitting there and being fought over. So under the new progressive release system, you'd have a progress payment, 10% is retained, and then after the 60 or 90-day period expires, those funds are released and flow down through the chain. And then the last point, as I said, is improved access to information rights. So the definition of an applicable person has been largely expanded. It includes a lien holder, a beneficiary of a trust, a contractor or a subcontractor who's currently under a contract with the relevant owner, contractor or subcontractor who's requesting information about a particular project under the contract. So they've been greatly expanded. And on top of that, you'll see there section 33 sub 7 now gives the court permission on an application to allow one of these applicable persons to inspect anything from the contracts, relevant documents, mortgage information. So all kinds of information is now accessible. And as I said, accessible to a larger group. And then the last little point there is section 20 now provides for electronic copies of the certificate of substantial performance. So gone are the days of oil and gas projects in particular having to have a piece of paper stapled up on the fence and timelines being dependent on those things. So in many ways they've tried to update the act, and this is sort of a small nod to that. So I'll pass it over to Jocelyn, who's going to go through the prompt payment system. Sorry, it's going to be Jordan. My apologies.
That's all right. Yeah, no, I'll just try and continue to build the hype for Jocelyn to go through the really hard stuff, which is adjudication without any of the applicable regulations being released yet. So we'll save the hard questions for Jocelyn. I'll take you through just briefly the overview of the prompt payment system, which, as Bryan mentioned and as noted in the at the start of this, that prompt payment gets central billing. So now the act is the Prompt Payment and Construction Lien Act. And this is really the part of the act, or the updates that were getting at the heart of the issue that industry was grappling with, which was what led to the groundswell of support for changes, both in the UK, which kind of started this global move, then in Ontario, which kicked things off in Canada, and in Alberta, which is really just the lifeblood of a construction project, and that's cash flow, keeping cash moving. This is also where most of the changes can be felt. Day to day, people dealing with the act or doing construction projects, these are going to be the timelines and the pieces of it that are going to really affect your business and what you're going to have to contend with. And hopefully you won't have to get into too many adjudications. But as you'll see, because of these timelines, the adjudication process needs to be top of mind, because that is really what's going to give teeth to these timelines. The act is going to depend for its enforcement on parties. And so if you're not in compliance with these timelines, the ramifications are going to be that you're going to end up in adjudication. So this slide here really tells you most of what you need to know from a high level. And what we see is at the start on the left-hand side is the proper invoice. Like Bryan said, that's what starts everything off. All the timelines start running from the issuance of a proper invoice, and that's just an invoice that complies with the Act and that sets out the required information that the Act says it has to have, as well as anything that might be added to it by the parties. That's going to start the first timeline that's relevant, which is this 14-day period to issue a notice of dispute. As Bryan said, if you don't issue that notice of dispute, the next timeline becomes relevant, which is the 28-day mark following the proper invoice, which states that the owner must pay any amounts that are stated to be owing under a proper invoice. And because of that obligatory language, that's what gave rise to the so-called smash and grab adjudications in other jurisdictions, and because the only exemption to that mandatory language in the Act is if the party has issued a notice of dispute within the 14-day period. And importantly, that 28-day period is going to apply for all amounts that haven't been disputed. So even if you dispute part of an invoice, the balance that hasn't been disputed must be paid. And the notice of dispute is going to have to set out the amount that's not being paid and detail all of the reasons for non-payment. So it's looking like it's going to have some substance to it, although it'll be interesting to see exactly how detailed your reasons have to be for the non-payment. Following that, once the owner has paid the contractor, the next timeline applies, which is 7 days from the receipt of payment or a notice of dispute. The contractor has to pay its subcontractors, and then that relative 7-day timing applies down the chain again. So it's 7 days from subcontractor to their subcontractor and material suppliers, and so on. So if we move on to the next slide, we can take a look at what the requirements of a proper invoice are. And we see there's some basic information like the contractor's name and address and the date. That's of course important because the parties are going to have to use that date to calculate the subsequent timelines. You have to set out the billing period for where the work was done pursuant to, information identifying the authority that the work was done under. And that's critical because that's going to help the owner identify to make sure that this invoice matches the purchase order or the overall contract. You have to describe what work was done, the amounts that are being requested, the contact information, and the name and title of the person to whom payment is going to be addressed to, and then a statement that indicates that this invoice is intended to be a proper invoice for the purposes of the Act. And importantly, it says any other information that may be prescribed. So parties can add to the requirements of the Act. You can't take away from them, but you can add additional information. And so that's going to be important, especially from the perspective of the accounts payable people. You want to put in anything in there that's going to facilitate the review of these invoices, anything that's going to speed up the process of being able to verify that the amounts in the invoice actually match the work that was done and that was authorized pursuant to the contract. One of the things that you cannot do, though, is you can't require that the invoice be conditional upon or the prior approval of another party. So you can't front load the process, and you can't say, the invoice must contain a provision that includes the approval of the consultant, for instance. Anything that makes the issuance of the proper invoice conditional will be invalid. The parties also can amend or revise a proper invoice. So if an invoice gets rendered, if there's a mistake on it, or if, say, there's an issue with over progressing and the owner can go directly to the contractor and sort that out, the parties can amend the proper invoice. However, the parties cannot amend the date, so the date would still apply. And this appears largely to protect the subcontractors, to make sure that the timelines are still kept and that funds keep moving. The Act does also require that a proper invoice be issued every 31 days. So that's the other protectionary mechanism for subcontractors, is to make sure that this process gets renewed every 31 days. There's really not a lot of teeth to that, except to if the subcontractors would be entitled to some form of relief if the contractor wasn't complying with that timeline. So after that proper invoice is issued, we get to the mechanics of the Act, and it's really simple. The owner has two choices: you can fight or you can pay, and if you don't fight, you're going to pay, and it's pretty well that simple. And part of this is that the ethos behind it is that conflict delayed is conflict multiplied. If issues get put off for a period of time, they're going to snowball, and if you've been involved with any projects where that happens, you see how quickly issues can snowball. So the underlying thought is, if you take issue with an invoice, bring it up, raise it now, and then the parties can deal with it. And what we see in the next slide is what happens if a notice of dispute is issued. Then the contractor, they have two choices, and that's to either pay their subcontractors, accept the notice of dispute and pay pay the subcontractors. Or if they don't want to be squeezed, if they don't want to be funding their subcontractors and material suppliers out of their own pocket, they're going to have to not only deliver a notice of non-payment to their subcontractors and the notice of dispute that they received from the owner, but they'll also have to undertake to commence an adjudication. So if you're in the position of the owner and you issue a notice of dispute, it's reasonably likely that you're going to find yourself in an adjudication within 21 days, as that's what the contractor will have to do. And again, that's to protect the subcontractors and the material suppliers who might not have the same relationship with the owner, might not have the ability to commence those processes. So one of the big questions is, who does this apply to? Who's now going to be subject to these payment timelines? And it's important to understand that the overall structure of the act remains the same, and the prompt payment regime has kind of been inserted into that. So understanding this, if you go back to all of the previous case law regarding when their lien rights apply, are going to still in large part apply to our prompt payment obligations going to apply. The best guidance that we have right now is going to be that line of authority. And as a shameless promotion of Bryan's book, Bryan helpfully has broken down the case law in Alberta that applies to what courts have considered to be lienable work and non-lienable work. And the key aspect there is whether it relates to an improvement to the lands. And what courts are largely looking at is, was this work reasonably necessary to make the improvement? A big line in the sand is between new construction and maintenance work. So, mowing lawns and that sort of thing, just routine maintenance is not lienable. And so that work would not be subject to the prompt payment timelines. It really has to be tied to new construction. And this idea of, have you improved the value of the land, or have you extended its workable life, or improved it beyond its original condition? That's going to likely give rise to these prompt payment obligations and lien rights and the whole host of obligations under the Act. Now, the government has recently introduced some amendments that have been discussed by the other panelists. This was put forward in the recent act, the Red Tape Reduction and Implementation Act. So the whole idea of that act was to try and simplify things and help business owners. And so part of what that applies to in the new Prompt Payment Act is they're going to try and make it a little bit more user friendly. So you don't have to go to legal every time you have a question about, does this particular project or does this contractor apply? They are looking to include in the regulations a list of the types of professionals or the types of projects or the types of entities that will be subject to the Act. So that should provide some guidance. But again, those amendments aren't yet in force, and the regulations haven't been released. Now, some common questions that come up are related to this notion of that 14-day period. What happens if I have missed that deadline? The consequences of it, from what we can see so far, from how the legislation is drafted and from how other jurisdictions with the same language have applied or have treated the issue, the contractor is likely entitled to payment. So that raises a pretty significant issue, which is, if you get to that day 12 or day 13 and you're starting to sweat because you don't have the internal approvals yet, what do you do? Now, there seems to be really two choices. One is to simply issue the notice of dispute. And one of the things to know there is whether the contractor has done anything which has led to there being issues with the review or approval of the work. Of course, if they didn't submit the required information to constitute a proper invoice, if you've stated in the contract that they're supposed to include certain information, then, well, you're in luck, because that's now not a proper invoice and the timeline did not apply. But you can also look to issuing that notice of dispute, or you'll want to put in your contracts an ability to withhold or issue notice of dispute on subsequent payment periods, on subsequent proper invoices for any defects or defaults in prior work. So you still have that right to go back and preserve that right, even if you pay under the existing proper invoice. And then once the approvals come through and it's discovered that work wasn't done or wasn't done to spec, you can still withhold against that subsequent invoice. And the last point there is what happens if the contractor doesn't issue this proper invoice for over 30 days. That's really in the act to protect the subcontractors. So it would be up to the subcontractors to launch an adjudication. It's to make sure that the funds are flowing down to them. If no work has been done on the project, the technical compliance with the act would be to just issue a nil invoice. But there wouldn't be much need to that, and so not likely much ramifications. That's really going to be an issue. If there are subcontractors who are not being paid, it's going to provide an issue. So owners may want to consider being able to go direct to the subcontractors and back charging the contractor. But that's really in the act. If you're a subcontractor and you haven't been paid and the issue is that the contractor hasn't issued the proper invoice, you would be able to commence adjudication and likely get some relief there. And so with that, we pass it over to really where the teeth of the act are and the enforcement of compliance with these timelines, and that's adjudication.
Just before Jocelyn gets going, I just wanted to add one piece of nuance. Jordan had mentioned who this will apply to, and that it applies generally to where lien rights would apply. And that's absolutely correct. The focus of where the case law has moved in Alberta is a focus on the project. So the focus is not on the type of service that's being provided. The focus is on whether or not it's related to a larger construction project. And so, for example, if there is a building that's being built or a transmission station or a drilling program, the focus is on that activity, that overall project. And basically anything that supports the overall project, including craft services and porta potties delivered to site and fencing that goes up around it and material supplies, all of that would fall under a service provided to the project and therefore part of the prompt payment regime. So you can see how quite expansive it is. And so when organizing internally and deciding whether or not prompt payment is going to apply or not, whether adjudication is going to apply or not, it's worth setting up the entire project code and the entire billing cycle underneath of it so that it applies to, so that it complies with the legislation. And I think that's an important aspect of this. If it's merely warehousing materials or building up for some unspecified work in the future, that likely wouldn't fall under prompt payment because it's not specific to an actual physical construction of something. And so those lines can be a little blurry, but we're always available to help if you have a question.
Yeah, that's a great point, Brian. And the classic example of snow removal, right? In the ordinary course, snow removal is not lienable. That's just regular maintenance work. If you're clearing snow from, say, a parking lot, that's not lienable. However, if you need to clear a site of snow in order to start excavation or start construction, then it could give rise to lien rights because it's connected, a necessary component of that construction process. So, the underlying intent is whether it's related to the new construction. And I just, before we'll pass it off, notice a question came in. Will a subtrade be able to lien a project when they receive notice of non-payment? Yes. I mean, the short answer is yes. I mean, the substance of the lien rights provision of the Act, with exception of modifying the timelines to apply a lien, but lien rights are largely unchanged. So yes, you'd still be able to avail yourself of the lien. An important thing to remember is that the lien process just provides the security for the payment. The prompt payment and then the adjudication provides for the actual means of payment, as opposed to just the security of the payment. But yes, you'll be able to lien a project if you've received a notice of non-payment.
Great. Well, thanks, Jordan. As Jordan says, I get the maybe difficult task of walking through the adjudication process, but we'll give it a whirl and see where we go. So, as you've heard, the adjudication is the new stick, as it were, for non-payment. What it is it's a non-judicial dispute resolution system, and it's going to be administered in Alberta by nominating authorities, potentially plural. Under the current legislation, we don't know who they are. They haven't yet been selected. We don't have a lot of information about that. It's all supposed to be coming in these regulations you've heard about, which are very mysterious and have yet to be unveiled. So the nominating authority and the adjudicators that are trained by the nominating authority are all supposed to work together to facilitate the process of this dispute resolution. So nominating authorities are going to be the ones to qualify the adjudicators, to provide training, to actually administer the hearings, as it were, to establish sort of the rules of procedure and that kind of thing. The adjudication process is designed to speed everything up. So rather than waiting 2 years in litigation, you will be quickly getting a decision from an adjudicator. And when I say quickly, in other jurisdictions, we're looking at roughly 30 days from start to finish. And so that is an incredibly quick process designed to get the money flowing while the project is still ongoing. Now, let's talk about who and what is going to go to adjudication. The current legislation says that disputes between contracting parties can go to adjudication. So that means there has to be a contract in place between the parties who are fighting. Disputes are going to be in regards to any prescribed matter. Obviously, the regulations having not yet been handed down, we don't have a list of prescribed matters, but what we do have is an idea based on the Ontario regime as to what we anticipate will be likely seen in our regulations. The Alberta Prompt Payment Group, who is currently devising the regulations, has advised us that essentially they're trying to model the Alberta process loosely on the Ontario process. And so we anticipate there will be simple debt claims, workmanship issues, change order disputes, impact claims, sort of the bread and butter construction claims, as they were. What that process is going to look like, we still don't know. The procedures are going to be set by the regulations, and then there will be additions to the regulations by each nominating authority. So depending on how many authorities they are, they might have slightly different procedures put in place. Parties themselves can add to those procedures, but you cannot subtract from the procedures that are going to be found in the regulations and through the nominating authorities. So just something to think about as you move forward in terms of what you might like to see for procedures and where they don't conflict with the existing procedures once we know them. It's a great idea to put those into a contract. The process, again, designed to be quick, and under the Bill 62, there's a bit of changing landscape in terms of, as Bryan mentioned, the legislation originally was final and binding for adjudication. So that meant the only way you're getting out of this adjudication is to do a judicial review on very, very narrow and specific terms. And so the government unveiled that, and the industry reacted and said, that's not at all what we wanted. Please don't make that the final say. And so the government has gone back to the drawing board and tried to model more of the Ontario model, which is an interim binding or a default binding sort of model. So now under Bill 62, you have some additional options beyond just the judicial review. So judicial review is what challenges the actual adjudication decision itself. However, if the adjudication decision comes down and the parties have an arbitration agreement, a written arbitration agreement, where they've said, under the Arbitration Act, we will select an arbiter and we will send all of our disputes to arbitration, then the parties can proceed through arbitration and the arbiter can decide the merits of exactly what was before the adjudicator without any fuss about that. Further, you can go to court. And a court, it says right in Bill 62, they now have the ability to hear the merits of what has already been decided in adjudication. So functionally, what ends up happening is that the adjudication is binding unless and until further steps are taken. And so if there's another decision of a court or if there's a decision of an arbiter, then ultimately that is the last say, or you can settle it if you want to settle it. Then ultimately that's the last say. But in the interim, as Bryan says, which can be a long time, you're stuck with the adjudication unless you go through the judicial review process and challenge it that way. So preparing for an adjudication, obviously we're still working a bit in the dark because we do not have the regulations. But what we do know so far, what's in the legislation and what we can see in other jurisdictions, tells us that once again, it's about being prepared and it's about contract administration being king. At the end of the day, you're going to be expected on a very, very tight timeline to be able to respond to a claim, to a dispute, and to be able to prove your case in front of an adjudicator and argue the merits of your case. And so the number one issue that's going to arise is for those who aren't organized, putting together your claim when the other side has got a 200-page claim and has spent 6 months organizing themselves. To spend 5 days getting organized is going to be a stretch. And so I think the biggest thing to take away is that you're going to need some sort of a procedure and some sort of an internal management system that allows you to very confidently say you can put your hands on every single piece of paper you need to almost immediately. And you need to be vigilant about what the other side is doing. You know, this idea that they've put together their 200-page claim, they might have been padding the record that whole time. And if you're aware of it and you've got your eyes on that, then you'll know that you need to be working in the background as well, and you won't be taken by surprise. No one wants that Christmas Eve drop on your doorstep gift, and yet oftentimes the signs were all there and people just missed them. So it's going to be very, very important to stay on top of your contract administration and keep yourselves organized. So we have lots of other suggestions, and as the regulations roll out, I'm sure there will be even more little tips and tricks that we can share. But for now, those are our sort of high level. And then I'm going to pass it over to David, who's going to talk a little bit more about the practical considerations for what to put in a contract or how to adapt yourselves to this bright new world we face.
Jocelyn. I will touch briefly on some practical considerations in light of the new legislation. So basically, I'm going to touch briefly on 3 main points. You should understand the legislation if you are unfamiliar with the Builders Lien Act or sort of the concepts behind the Prompt Payment Construction Lien Act are unfamiliar to you. You should spend a few minutes reading through it or read through a consolidated version of the Prompt Payment Construction Lien Act. There are a number of amendments out there, so this may not be something for everyone, and it is filled with legalese, but it is meant to be understandable and relatable enough for a layperson to follow. So it's not meant to be overly complicated, and it will help you understand how the various pieces fit together. Item number 2, obviously, review your contracts, review your paperwork, and understand whether captured or need to make amendments in order to capture the changes coming down. And I would suggest to you that probably almost everyone's contracts need some updating. CCDC contracts, if you're familiar with them, are fairly standard in the construction industry, and updates will come down the pipe there. But generally speaking, CCDC contracts are general and broad enough that they're meant to capture all these items. Nonetheless, you may not want to stick with sort of the general plain reading of a CCDC contract. And if you have your own internal contracts that you tend to use, then you should definitely take a moment to read through them and reflect on whether they capture or need to be changed in order to capture the changes in the Prompt Payment Construction Lien Act. And finally, understanding your own business's internal processes. I'll touch on that briefly afterwards, but in your contracts, there are a few items that we've sort of given some consideration to that we think are important for you to consider including. What constitutes a proper invoice is obviously going to be very critical. All the time frames start from receipt of a proper invoice, and the definition in the CLA has certain requirements, but as Jordan noted, there is sort of the catch-all phrase allowing you to include any additional items that you want in your proper invoice. And we would suggest it's important to capture everything you think is necessary in a proper invoice. Conditions subsequent to a proper invoice saying, you need to issue a proper invoice, and you need to give some certificates after the fact, are probably going to be unenforceable. You should just fit everything into the definition of a proper invoice. And even if that means you're getting a big stack of paper every month, at least it's a way of controlling and capturing everything you think is relevant to any particular invoice for your review right then and there. So certificates of the contractor, any declarations that you require about payments having been made to their workers or their employees, or occupational health and safety, or workers' comp, updated schedules or updated project budgets, anything you think is relevant to you in paying an invoice or in the next step of the project should be captured right there in the definition of a proper invoice. And if your contract doesn't currently contemplate the definition of a proper invoice, then that's the logical place to start is to include a definition that that contains everything that's in the proposed legislation, but then give a little bit of thought to the additional items you might want. We'd even go so far as to suggest that change orders, any change order that has been issued or any change order that's been issued in the last X number of days, give it a requirement in the proper invoice as well. Timelines for payments. You can stay back one slide, Andrew. Timelines for payments, although you'll notice them in the next slide, the critical one for you is that your payments are going to have to be made in 28 days. You may want to consider requiring the contractor or subcontractor, but in particular, if you're an owner of the prime contractor, to issue an invoice every 30 or 31 days. If that's something you want to do, just write it right in your contract. Include an obligation for them to issue an invoice every 30 days, even if there isn't necessarily much to be invoiced at the beginning or the end of a project. There's no sense in having a fight over something that you could have resolved by including a single sentence. Proper invoice. Dispute resolution mechanics. The CCDC contract and most contracts out there are going to have some provisions or have given some thought to a dispute resolution mechanic. Oftentimes you see contracts that have, senior leadership will negotiate. If they can't resolve something in 10 or 15 days, we'll move to mediation or we'll move to arbitration. Obviously, with adjudication being a right under the Act, it may throw a wrinkle into your current process, and you don't necessarily want to be, on the one hand, in the middle of mediation under your contract, and on the other hand, have the other party start an adjudication process, which then you're going to have competing streams of dispute resolution mechanics, and it can get messy, or we can imagine ways that it might get messy. So the suggestion would be fit adjudication right into the process. You can't take away the other party's right to adjudicate, but you can obligate any kind of claim to go through adjudication as quickly as possible. And so you can fit it right into the mechanics of how you're going to resolve your disputes. As Jocelyn mentioned, there are going to be some outs in the adjudication process that might turn it from final and binding into interim. And so, there's if you enter into an arbitration agreement, or if you have language that says the parties have agreed on an arbitrator and will, resolve their dispute under the Arbitration Act, put something like that in your contract already. Again, you can have more, or you can have further provisions about how you will treat something under the Arbitration Act, or how an item or a claim will be arbitrated. But there's, in the plain reading of the Act, it says, if the parties have agreed to an arbitrator under the Arbitration Act, then adjudication will potentially be interim. There's no sense in not including such a sentence, or not already predetermining who your arbitrator will be and just dealing with it right within your contract. There's, as far as we can tell, there isn't necessarily a requirement to go out and get a standalone agreement to arbitrate, but there's no harm in fitting it into your contract upfront now. And so some of these items are obviously prone to, as more information comes out, or as some of these items are challenged in court and case law is established, we'll have a better idea of some of the mechanics behind these items and whether what we're suggesting works or needs refinement. But as things stand right now, these are some simple steps that you can take in order to potentially head off some major issues down the road. Treatment of holdbacks, progressive release of holdbacks is something that might be provided for. You might want to give some consideration as to whether you want to be halfway down the road with a project and someone starts making progressive holdback release claims. These are items, again, to your contract. What does it say about holdbacks? Does it say something as simple as, holdbacks will be handled in accordance with the relevant lien legislation in a province? If so, you might want to consider fleshing that out a little bit if you want progressive release of lien holdbacks to be allowed or not. And so once you've reviewed your contracts, we come back to sort of understanding your invoicing procedure, but not just your invoicing procedure at the office level. You need your accountants to understand what a proper invoice looks like. You need those invoices to get pushed to the appropriate personnel for review as quickly as possible. You're only going to have 14 days from when that invoice lands on someone's desk in order to issue a notice of dispute. And if you're a large organization, you might have multiple levels of people that need to take a look at something. You might have, project site supervisors who need input. You might have consultants that have to provide some input as to whether those payments are valid, whether what's being claimed under that invoice is valid. And you're going to have to give a bit of thought. It's asking a lot, I think, of some organizations to review invoices and say yes or no, or to part of that invoice in 14 days. But that is sort of where the government is going. Alberta is not the first, and they won't be the last, but this is the direction that they're pushing in order to protect subtrades. And so you're going to have to review your internal business practice and see what slows you down and how you can make it quicker. We've seen some clients, they have complicated reminder systems in place so that people provide input when necessary, or if a consultant needs to review something on behalf of a lender before the money comes to you and that money gets pushed down to your contractor. Again, there's going to be a lot of people that you might theoretically have to get this invoice into the hands of. And so it goes back to my initial suggestion, which is in your proper invoice, make it a requirement to include everything you think appropriate people are going to need to see in order to adequately service or determine whether that invoice is proper or not, and what money isn't going to get paid. And so I think that covers the broad strokes. It's just understand the legislation, read your contracts, understand how that's going to impact your business. I will now turn it over to Scott.
And just before Scott gets going, I know that we're at the top of the hour here, and sometimes there's a drop off at this point, even though we're scheduled to go to 1:30. I encourage everyone that can to listen through to Scott's presentation, as it's extremely interesting to see how this thing has been affected in other jurisdictions. There was also one question in just asking how adjudicators will be paid. I think the answer is it's yet to be revealed because it's supposed to be done by and in accordance with the adjudication procedures set out in the regulations or established by the responsible nominating authority. There's no nominating authority and there's no regulations, so we don't know yet. One may presume that it is likely that adjudicators will be paid proportionately or in half between the two parties that are subject to the adjudication. Scott, over to you.
Yeah, Brian, I might actually, good afternoon, everyone. I might just add a bit to that from the Ontario experience. In Ontario, the Act says that the adjudicator itself or themselves are entitled to determine how the parties will be paid, unless the parties, have agreed otherwise. There is a default provision in the Act, but I don't think that if you see a, loser pays type approach, that would be that uncommon. So that's what's happening here. Obviously in Ontario, it hasn't been tested, but we'll go through it. I've been asked to talk about lessons from other jurisdictions, partly because although I'm Canadian born, I'm Australian trained and I practiced in Australia. And then for my foolishness, I practiced for 8 years in the UK before coming back here to Canada. And I saw the emergence of the prompt payment or the Building and Construction Industry Security of Payment Act, it was called, nice handle in Australia, plus the Housing Grants Regeneration, Construction and Regeneration Act in the UK. So I have lived some of this firsthand, and that's why I thought it might be able to guide people in Alberta as to what might be interesting to you. I tried to pick from the basically 60 years cumulative of experience in Australia and the UK that they have had with essentially the Prompt Payment Act type provisions that you guys are looking at in Alberta, and that we now for a couple of years have had in Ontario. Some of the things, just to be aware of. Quick background, I'll try to keep it very fast. 1996 now is coming up. Very long time ago, there was a report, as the UK does, construction in the UK had been, less and less efficient. I don't think things are changing anywhere in the world right now. But the whole thing was, the genesis of the whole thing was a report that came out in 1994 trying to fix the UK construction industry from the government's point of view. Construction at the time in the 90s, what a surprise, it was the UK. Where unions were strong and historically, construction was considered to be very adversarial. The processes were ineffective, and the government considered that most projects or most contracts were incapable of delivering a project on time. So they looked at how they could essentially improve things. They engaged Justice Latham, who did a very detailed and now relatively famous report. And remarkably for governments, they enacted just about all of the recommendations in the report at that time. So they did some of the things that you've heard about today. The UK prohibited pay when paid. They prohibited contracting out, which is the first thing that everyone wanted to try. Lawyers then responded with, well, what about pay when certified? We're going to pay you when we certify, and we just won't certify for a couple of months. Courts quickly, stomped on that one. They introduced prompt payment provisions exactly like the nature of the prompt payment provisions being introduced here. Curiously, at the time, they introduced this concept of binding but not final adjudication. The loser pays, as Justice Tulum said. The whole concept of the idea is pay now, argue later. We can figure it out now, but we have to grease the wheels. The expression greasing the wheels has come out more than once in both of those other jurisdictions, and that's what the government was looking to do. Since that time, I'll talk a little bit more about what's happened in these places, but the courts have been slow to accept the lawyers' technical legal, tricks and arguments. They've been slow to overturn decisions on the basis of errors of law or excess of jurisdiction, because they're trying to, give force to the approach that they've taken. As you can see from the diagrams at the bottom on the left, you'll see the growth in referrals. It's pretty dramatic in the UK. From year 1 to year 3, it went from 0 adjudications to nearly 2,000 in the UK, and it's sort of settled in over the years to around 1,500 per year, which is significant. More interestingly, on the other side, you can see there's a direct inverse proportion between litigation and adjudications in the UK. So once adjudications started to take over, there was an exact corresponding reduction in the litigation cases, which was precisely what the government was hoping for. They, effectively greased the wheels. They gave people quick and nasty dispute resolution, and it seemed to have worked. Moving on, Australia's probably closer to the UK than Canada is in most ways. 3 years later, the Australians who are watching the UK, they started to talk about their own problems. In Australia, I happened to be living there and was working there at the time when this happened. They followed the UK experience 3 years later. New South Wales, where Sydney is, the largest city, started first in about 1999 with what was then a relatively controversial, method of following the UK. Sorry. Other states, then, since you've seen, consider this a success. So between 2002 and 2009, just about all the rest of all these states have enacted similar legislation. Australia, like Canada, has this legislation on a state-by-state basis. So there's no federal act, but each state enacted their own. And as Alberta and Ontario, some states get along better with others. Some deliberately chose not to do what New South Wales was doing. Some chose to follow quite closely. Ironically, since all of the states have enacted their own legislation, broadly speaking, most of the states now have reenacted subsequent legislation to bring their own acts all into more or less alignment. So if you're a cross-border contractor acting in various states in Australia, as you may be in various provinces in Canada, the acts are now largely the same, with some small differences. The purpose in Australia was designed to reduce the power imbalance in the payment chain. Sounds familiar in Alberta? The Aussies expressly said they were really going to go after this and make things quick. They introduced prompt payment. Ironically, there's a time cutoff for adjudication. So there's not only a rush to respond, but there's a rush to get your adjudication in. If you are a claimant and you haven't submitted your adjudication within time, you're actually prohibited from submitting an adjudication that is stale. Now, my own view is that period is about 20 business days. Probably the reason that the governments thought that was okay is because by the next month, you've got another payment claim comes out and another round goes ahead, and you can restart your adjudication process. In New South Wales, they decided it would be monetary disputes only, money only. But my own view, having experienced what things are in that country, just about everything in construction, directly or indirectly, touches on money. And so the purview of adjudication was quite large. No pay when paid, no contracting out, exactly like the UK. They emphasize in Australia speed and informality. And as you can see from the graphic at the bottom, 10 business days from the appointment of the adjudicator until the adjudicator is supposed to issue his award, absent the parties agreeing anything. 10 business days can be extremely fast. The other unusual thing in Australia that was really effective is certainly there's a statute, it's an operation, a statute, that payment is enforceable in New South Wales by what's known as, colloquially, as an assignment order. So when a subcontractor is owed money by the contractor, gets his decision within 10 business days from the adjudicator, he goes off to the owner with an assignment order, which the court will quickly issue. And he says to the owner, look, any money you owe to the contractor, you now pay directly to me, and it is deemed to be paid to the contractor, so you're off the hook. And that has very much greased the wheels in that country. Moving on. Tips and tricks, lessons learned from the UK and Australia, and I think that's really why I'm here to talk to you guys about what's going on. The first thing to note, and largely most of my discussion, frankly, is about the adjudication side. The prompt payment side is probably less controversial. Generally speaking, adjudication has been regarded as a blessing by the construction industry, says Justice Coulson in the UK in 2015. And I think that's also true in Australia, and I would be very unsurprised if it was not considered to be the same, or very surprised if it was considered to be any different in Canada. Let's put it like that. Adjudication really has been pretty much a success in most jurisdictions where it's been introduced, which is surprised why it was introduced in Ontario. They say in both of those countries, adjudication is not final. It's binding, but not final, which is kind of a curious animal. And people really weren't sure exactly how it was going to work. Practically speaking, most parties or many parties are usually exhausted by the first round battle that they have in an adjudication. And more often than not, they finish at the end of adjudication. You know, rarely people keep going if they think they got a terrible decision, but most of the time, adjudication works as it was intended. Statistically, and I don't really know the background for why this statistic is like it is, perhaps because the money was actually owed, which is why people go to adjudication, but there is a high proportion of claim recovery. About 70% of the money claimed generally gets paid. Now, you could be suspicious and say that's because adjudicators are contractor friendly or, you know, payee friendly, but you could also take the view that the reason that 70% was recovered is because 70% or more was probably owed in the first place. Legally speaking, yes, there were and still are lots of cases, or not lots of cases, a few cases about the adjudication process. Questions about when it's enforceable, errors that are made in the process, dueling adjudications, both parties purport to start an adjudication, technical non-compliance. In Australia, for instance, there was a requirement in the Act that said, you must say on your invoice that this is an invoice issued under the Building and Construction Industry Security of Payment Act, which is a big handle. Somebody misspelled it and said, this is an invoice under the Security of Building Industry Act. And the other party took it to court. The courts took one look at it and said, that's your objection, that they got the footer wrong in the invoice. And that famously the judge said, that might have worked in 1860, but it doesn't work now. And he threw the case out and said, go pay it. So that's the kind of thing that's been tested there. Interestingly, when you get lawyers involved and they're paid by their client to think up great ideas, there's no lack of tricks. The one that you've probably heard about already this afternoon, the ambush. The ambush was real. The one aspect of adjudication that is not time constrained, and this is important to remember, there's one aspect of adjudication that has no constraint on time whatsoever: how long it takes the first person to prepare the first shot. So initial preparation is not time constrained. It is not unheard of for parties to spend a very long time getting ready and dumping on the other party. The Christmas present, one of the legendary cases, I suppose you'd say, Dorchester Hotel. It's an interiors case, 2009. The claim came out just before Christmas, December 19th. The claimant drops a 92-page statement of claim, 37 binders of evidence on the other side, just before Christmas. Merry Christmas. I'll see you on January the 6th with your response. And actually, that case is probably not the best example because even the adjudicator said, no way, I am not counting days over Christmas. But the intent was quite clear. The Act was clear. The UK, foolishly, was counting in days and not business days. And so time was against the party responding. It was tested. The courts looked at it and said, sorry about that, but we're going to give priority to the rough and ready adjudication process. So they declined to throw the process out. And they said, you've got to be ready. The other curious thing to be ready for is what's known in the UK, at least, as scooping the pool. I think Jordan talked about what happens if you don't comply with the process. So 2015 case in the UK, two parties get involved in a small £8 million contract. What's that, $12 million, something like that. They're waiting, they're getting through the contract, they wait for the final claim. The owner expects the claim to be £150,000, maybe, something like that. Contractor marches in, instead of $150,000, $4 million is the final claim. 50% of the contract price at the very end. Oh, surprise, I got a bunch of change orders and some disputes. The owner, of course, indignant, refuses to pay, refuses or doesn't, fails to issue a notice, fails to issue what's known in the UK as a pay less notice, doesn't pay. Contractor quietly sits and waits. 2 weeks later, time expires, marches off to the court and gets summary judgment for £4 million. The owner's argument, of course, was, you got to be kidding. Not a very strong argument in court usually. And they ended up having to pay. Now, as we talked about, you might get a chance, you might get another bite of the cherry. to reset the invoice on the next month. In this case, it was supposed to be a final invoice. There was no next month, so there was no ability to recoup the money. So they went to court and tried to get it back and failed. The other interesting thing that doesn't happen in Ontario, but may well happen in Alberta, is influencing the choice of adjudicators. I see that in Alberta, there are going to be a bunch of authorized nominating bodies, as there are in both the UK and Australia, but not in Ontario. What happens is people decide who they're going to want as an adjudicator unilaterally. So they have been known in the past to call up the authorized nominating body, which in the UK, for instance, might be the Royal Institution of Architects, or in Australia, the RAIA, the Royal Australian Institute of Architects. And they speak to the person that they know at the front desk, who happens to be the nominating person, and they say, hey, you know, our case would be perfect for somebody like Bryan West. Is Bryan West available as an adjudicator? And the person that, you know, they're familiar with, they've probably gone to lunch with, says, let me look. Yeah, Bryan West is on our list. Sure, we can let you use Bryan West. And they nominate, the authorized nominating authority nominates that person as the adjudicator. Now, unbeknownst to the other party, who probably would be very unhappy to find out that that's how the adjudicator got nominated. So in Alberta, I would be unsurprised to find you're going to get a little bit of those kinds of try-on. Or maybe you want to try it yourself, who knows. Lastly, Ontario has a curious process. David talked about proper invoices. If you don't submit a proper invoice, you're deemed not to have submitted an invoice that's capable of paying. I have at least one client in Ontario who said, and they have a list of requirements for a proper invoice, probably a page long, most of which is legitimate. They have said, if you fail, Mr. Contractor, to submit a proper invoice, you're going to be deemed to have submitted your proper invoice, not when you fix it in a couple of days, but next month. I said to my client, is that even possible? They said, read the act. Do you think it's possible? And under the act, it's unclear right now whether it's possible, but you might be able to deem that an invoice that is improperly submitted is deemed submitted later. I jokingly said to my client, why don't we deem that it's submitted in 2025 instead of next month? Save yourself some money. I think that is ripe for testing here in Ontario. So those are some tricks from other jurisdictions. You're probably more interested in what's happening in Ontario. So a little bit of color, I guess, on adjudications. First question, who do you get as adjudicators? You'd think that mostly would be lawyers, perhaps, because it's quite legalistic, but it's not. In Ontario, there are 65 adjudicators currently in the last couple of years who have been approved. Most of the people who applied got through testing and the training process. For what it's worth, 62 of the 65 are male. There are 3 women, all of whom are highly qualified. The split, as you can see, is actually much broader than you think. It's largely industry people, not many legal people, lots of project managers, engineers, quantity surveyors, a couple of architects and an accountant. That number, by the way, adds up to more than 65 because many of the adjudicators are multiple qualified. You know, some have 3 or 4 qualifications. They are an engineer, project manager, you know, an accountant, something like that. The range people paid range between $250 an hour to a couple of guys, $650, $750 per hour, but the average is around $400. I called the Ontario Dispute Adjudication Committee and asked them about what's happening in adjudications. Interestingly, in the first year, they released a report. They had, you know, notices of adjudication, 32, almost all residential. The remarkable statistic in that was the number of adjudications that were withdrawn before an adjudicator was even appointed. You ask, or I ask myself why that might happen. It occurs to me that it's probably because when faced with an adjudication, quick and nasty, most people who didn't pay didn't really have an excuse. They just didn't pay because they didn't feel like it. As soon as adjudication came out, they thought, well, I better write that check. Andrew, if you could, there's a little bit of an update in there. I called them the other day. Since the last report came out, they've started only 19 more, perhaps not so many because of COVID. They have made 26 determinations, not a lot in Ontario. But the interesting things, almost all of them residential, and almost all of them top level. So the adjudications are all between the general contractor and the owner. I think the ODAC themselves were surprised there was not a single subcontractor or sub-supplier adjudication requested. About half of them were agreed between the parties who the adjudicator would be. The other half were appointed by the ODAC. Now, here's the other interesting thing. I know Jocelyn said something about when you're appearing in front of an adjudicator. In fact, there are almost no appearances in front of an adjudicator. The ODAC said there's only been one site visit out of all the adjudications that were started. Only 4 or 5 of the adjudications actually had oral hearings. And for my own contracts, when I write contracts, I actually say that adjudications less than maybe $250,000 are going to be done on paper submissions only. No hearings, no evidence except what's written and submitted. That lets the adjudicator actually get a quick sense of what's really going on. So far in Ontario, 0 requests for extensions, which suggests that the process has been working. I think that's the end of my presentation. We'll move on. Thank you all very much. If we have time, we will open up to questions. I see there's a lot of chat questions. So Bryan, I'll turn it back over to you.
Thanks very much, Scott. That's really interesting. And I know that you've indicated before that the adjudication system itself may be scaring parties straight in the sense that even just its existence is inducing parties towards compromise before they even get to the notice phase.
Absolutely. Yeah, absolutely. I mean, certainly the Australians had a habit of just not paying because they didn't feel like it, frankly. And when you were a big 900-pound gorilla owner or contractor, you just waited for someone to sue you, and you had deeper pockets than they did, so you delayed, obfuscated, you did all the tricks you can in litigation. You asked for security for costs because you could, because the other side might not be able to pay if they lost, all the time knowing full well that you really did owe them the money and you just couldn't be bothered paying. So adjudication really greased the wheels in that case. And, you know, as it should be, because that's, you know, as Jordan said, cash flow is the lifeblood of the construction industry.
Right. Well, we do. Well, thank you again. We do have a number of questions in, and we'll try and get to them all here. First question is, assuming the Act does come into force on July 1st, 2021, how would you recommend handling payment terms in a prime contract that's being entered into now with a pre-construction phase when subcontracts are not going to be entered into until the fall after the tendering process? My initial answer is this, and I test it with the rest of the group, which is to say that because of the hard and fast rule of July 1st being the date, if the primary contract is entered into now, the rules that would apply to that contract would be the old rules. Given that a proper invoice that kicks off the entire prompt payment process happens when the contractor gives the owner that proper invoice, there may not be a prompt payment trigger event that would happen in that context under that particular contract. So I guess sort of fruit of the tree, if the subcontracts are arriving underneath of the prime contract, it's at least academically reasonable to suggest that subcontracts would also not be operating under the same process. That being said, adjudication would likely still be available and applicable after July 1st. Now, that is my top of the head answer. Team, what do you think?
I think that there's probably a little bit of ambiguity there because the transitional provisions of the Act, it does specify it, meaning it says any contracts or subcontracts which are entered before the Act the new Act comes into place, the old provisions apply. Any subcontract or contract entered after the new provisions apply. So because they've broken it out and they haven't specified that, you know, where there's a contract and its subcontracts, it could be ambiguous. So, I mean, you know, a suspender and belt approach in the law is somewhat fashionable. So, you know, you could, in order to save yourself the grief of having a head contract that's under the old terms and subcontracts that are under the new terms, you could just write in like that. There's freedom of contract still does apply to a certain extent, and there's nothing that would prohibit you from writing in effectively the new provisions of the act into the head contract and just specify that the timelines apply to parties. You can have a contractual right to adjudication in your contract, so you can make equivalent provisions contractually to the head agreement, and then say, you know, when the new act comes into force, it will be applicable. Its terms will govern this contract.
And I might add probably some unhelpful color from Ontario. Ontario took a slightly different approach because they actually predicated the application on the tendering process having started before or after a given date. So what we found here was many parties, correctly or artificially, I'm not sure, I didn't inquire too carefully, got together and they agreed that they had started their tendering process before the date, so they didn't have to be caught by the act. I think ultimately that's going to just fade away, by the normal effluxion of time. But I would say more than once we were told, oh, by the way, did we mention that, oh, this thing that we're signing now several months after the date, we started procurement before October 1st, 2019. So we're exempt from the act, aren't we? And we said, well, if you did, you are. And that's the approach that they took. And I don't know whether you can do that in Alberta or not, but anecdotally, that's what happened.
Now that we've given you those nuanced answers, let's try this one. How did contractual milestones for progressive release of holdback affect cap liability of owner GC in respect of the supply chain if holdback funds are released and a lien gets filed later in the project? Andrew, do you want to tackle this one?
Just repeat the last part, please. Caps on.
So I think the question here is saying if there's a cap on the liability of the owner, how does this progressive release of the holdback affect that cap liability if the funds are being released? And I think the primary issue here is that if you remember back to the construction pyramid that we showed you before and the attachment to the holdback fund, well, what's happening is that jar is being emptied out. And if your lien doesn't attach to that jar before it gets emptied out, and you're going to all that's going to be available is the next fill up. So instead of having access to the 10% plus the 10% plus the 10%, now you've only got access to the 10% of one progressive payment, for example. I think that answers the question, or I think that's getting at what the question is geared at. Does that make sense, Andrew?
Yeah, no, that makes sense. I mean, the point being the pot is not able to get as large. So there's some pros and cons for everybody in the pyramid with respect to that. But yeah, I think that's it.
The reason that the government's doing this, and this was progressive release of holdbacks is basically standard in every other jurisdiction. We're very late to the party on that. But you can imagine in multi-year projects, the contractor, the subcontractors, they're holding the bag for a long time, waiting for that 10% to be released until the end of the project, and that can be an ill-defined period. And so there's been many complaints within the system, and particularly in the oil and gas and energy sector, saying we can't wait 2 years to get our 10%. That's our entire profit margin. So it's instead of what's happened in many of the industries where they just pay it out anyway and the owner just takes the risk. Now this provides a way and a function that's applicable with the law to satisfy that problem of the multi-year project or the very large project.
Right, I was going to say, anecdotally in Ontario with Union Station, the main train station in downtown Toronto, there are apparently subcontractors who have waited more than 8 years for their release of holdback after they have been finished their work. That's how bad things can be if you don't have progressive release.
this next question, and maybe this is for Jordan, if payment obligation, or perhaps maybe this is Jocelyn. Well, in any event, whoever wants to speak to it. If the payment obligation under a proper invoice cannot be conditioned on the issuance of a certificate from a consultant or other payment certifier, what is the role of that payment certifier going forward? And the example here is advising owner or construction lender on what portion of the invoice to pay and what portion to dispute. I open up to the floor, whoever wants to speak to that issue. One thing that comes to mind is it could be an adjudicator.
Yeah, no, I think that the question had the answer in it, which is really that the consultant doesn't have a role pre-proper invoice issuance. It's post, and it would be in the ordinary course. I mean, if they're advising the owner, if they're retained by the owner, they would be the ones certifying that the invoice actually matches. Like if it's a classic progress invoice that says we've achieved 75%, well, they would be the ones counting the screws to make sure that that they are at 75%. So it is a really accelerated timeline for them to do that review and approval. But to the extent that they're involved in the approval of payment, it would just be the providing advice and direction to the owner.
And arguably there could be even a greater role, or at least, or maybe not a greater role, but expanded to more projects, in the sense that keeping track of these things and being on top of it is even more important now.
It might become less of they come in at discrete times and review, and more so that they need to be around all the time to understand the status of the project every 30 days, right? Because there might not be a chance for them to show up 5 days after an invoice is issued once the clock starts running.
I would say, if I can chip in, my experience overseas is the role is identical. It's just that they have to hurry up because you need to get it done within the first short period. And so, in fact, they become more proactive, so that in many cases, you do a draft invoice or you do a walk down with the consultant to expedite the process. So the role is the same or more in many ways.
And then finally here, we've got, given the need for invoices to be disputed within 14 days by the owner, can Jocelyn elaborate on scenarios in which a party would have the opportunity to prepare a robust claim, which can be sprung on an unsuspecting party? I think Scott gave one classic example from the UK. Jocelyn?
Yeah, so I think just to be very clear, the adjudication process is a lot broader than just disputing non-payment. And so it's going to be your first stop for all disputes in the prescribed matters, whatever those might be under the regulations. But for any matter that's prescribed between the contracting parties, your first stop is adjudication. And so that can be things like impact claims, which could be huge and could be, 37 binders of information. Who knows what that's going to look like. So it's not just individual invoices, but it can be something much larger because of the language of the contract and the legislation. And we don't yet know what those prescribed matters are going to be because we don't have the regulations, but we're anticipating that, like in Ontario, it's going to be your standard construction dispute claims, which, as we all know, can be quite large and can span more than one or two pay cycles and might actually span the length of the project.
Yeah, I think that the piece that's really having people concerned are having to run an impact claim or delay claims through adjudication, because those do almost by their own nature span the entirety of the project, right? If in month 2 all of a sudden delays start coming in and they snowball and pile up through the life of the project, that's really where you'd see this papering of claims and the building of a huge long report. And then at the end of the project, which was supposed to take 1 year, it actually took 3. And now there's all this correspondence, 3 years worth of correspondence and site visits and logs worth of claims. And if the contractor has built that claim the entire way, then at the end, that's where they would drop it, because of course, that it would be a claim for a change order, right? Is an impact claim, ultimately saying, the time and impact caused additional time and expense, so you should pay me for this. So it's really a dispute about the change order of the impact. That's where you get a massive claim, and it's really not suited well at all for adjudication, but that is the first step along the way if a party is so inclined. So some advice is to consider, if you're an owner and you know that that's coming, or you have an inclination that you've seen a change order request and it's hinting at this, and there's a potential dispute about that where you're not seeing eye to eye, you can prophylactically start an adjudication to get ahead of it, to say, let's get an adjudicator's decision as to whether this site condition actually is a material disruption, and do it right off in the process before there's many months and years worth of disputes.
Yeah. The other solution that has come up again in other jurisdictions, including in Ontario, is to roll various documents into the definition of a proper invoice, including those that are directed explicitly at flushing out claims, and asking people to say in your proper invoice, here's the list of all my disputed claims right now. You get your CCDC 9A 9B stat deck, but never stopped anybody from asking for more, whether they're enforceable or not. Please tell me you have no disputes this month. So that's not uncommon, and to the extent it's enforceable, I would recommend it. It's good project management to know whether you've got a dispute lurking. The last thing you want is the day before substantial performance is supposed to arrive, and guess what? You got a claim for a year, and so am I supposed to be finished tomorrow or a year from tomorrow? Anyway.
Okay, so we're a little bit past our overall presentation time. So there's one last question which I'll attempt to answer, and then I think we'll call it a day. I'll just plug, we're going to be continuing to do updates on the McCarthy blog, Lay of the Land. Also, we're launching a new website, might go live tomorrow, constructionlawcanada.com, where we're going to have commentary on this as it continues to develop and as the regulations come out. So those are other resources that you might avail yourself of. And of course, anyone here is happy to take your call at any time on any of these issues as they arise and as the Act becomes implemented. The last question was simply about the transition of July 1st and whether or not, for example, tendering processes that have started, contract A has started to be entered into, and will there be grandfathering provisions? The answer is no, there are no grandfathering provisions. The Act, unlike the Ontario implementation, is pretty hard and fast. It talks about the entering into a contract or subcontract prior to the coming in force of the Builders Lien Prompt Payment and Amendment Act. Again, that it's supposed to be July 1st. It may not be July 1st. So if you're on one side or the other, it seems like a pretty hard and fast rule. I think that there is likely to be some litigation around has a contract been entered into, and that's just contract principles. And in a procurement context, does contract A count as entering into a contract? And so those things may be litigated and disputed in the future. But we don't have, I think it's going to be on a fact-by-fact basis, and it really is that entering into before the Act comes into force. So that's the final question that we had up on the board. I want to thank everyone, especially the presenters, for attending today. Thank you very much for your time. Thank you for all the efforts that you put into this, following the developments that have been happening both here, abroad, and within the country. We'll continue to keep up to date on this stuff and provide that information through the various forums that we've identified. So thank you very much. That's it for now.